So anytime you're in a courtroom, you have a judge and you have a jury.
Right.
And the judge is what's called the judge of the law, right? And you've run into this many times.
Absolutely.
How many times have we told as
Absolutely.
young high schoolers this over the years? But the judge is a judge of the law. He decides what evidence comes in. He decides what questions can be asked. He decides what evidence makes it to the jury. But he is not allowed to have an opinion on the facts at all. There's only one trier of the facts, only one judge of the facts in a courtroom, and that's the jury. And the jury has to take all of this evidence, and in this case, both sides are putting up evidence. They have to take all this evidence and mesh it together to see if the state has proven its burden. And beyond a reasonable doubt, the standard to which someone has to be found guilty is the highest burden under the law. It's a big one. It's a big one. And it should be, because you're taking away someone's liberty.
Right.
And because you're taking away someone's liberty or trying to take away someone's liberty, the burden should be completely on the state. And it should be a very high and haughty burden. You know, the old adage is that better 100 guilty men go free than one innocent man go to prison. And one of the reasons that I quit being a prosecutor and became a defense lawyer is that eventually I thought that the criminal law and particularly prosecution was going to be my calling, you know, as a young lawyer. And as a number of years going through it, I became disillusioned with the fact that everybody's got a side. And one thing that a prosecutor's oath is supposed to be too, and a prosecutor's job should be every day, is to always do the best right thing. It should never be about ego. And what you'll find a lot of times, particularly in bigger cases, is that people get obsessed with trying to win.
Right.
And that's okay in civil court, right? That's what you do,
That's
right?
what I'm trying to do.
And you're trying to
every
win
day.
because in civil court you got the scales of justice, and if it tips ever so slightly one way, that side wins. In the criminal law, it's different, right? The state has that burden, but the state's burden is also to justice. And to get blinded by trying to run somebody down, to convict someone as opposed to find justice is disheartening,
right,
to me.
And we're not, again, today, neither you nor me are here to, I mean, we don't know what happened any more than anybody else does.
Not at all.
And, you know, the jury will hear the case, the jury will make a decision. You know, one of the questions I've been asked so many times is, do you think he did it? Do you think he's guilty? And my response is, you know, I may have my thoughts. I may think this or I may think that, but our criminal justice system, our law is not based on what we think might have happened. And it's got to be proven. But before we leave this subject of direct and circumstantial evidence, because you made a good point a while ago about how sometimes things can be direct and circumstantial, and they kind of overlap. One of the things that's been a key piece of evidence in this trial thus far is this Snapchat, whatever video that was taken by the son Paul down at the kennels. It was taken, and they've been able to establish through the phone records or whatever that it was taken about 8:45 p.m. And they've had multiple witnesses, family, friends, whatever, who know them all or knew them all very well, who have been able to say, that's Paul's voice, that's Maggie's voice, that's Alex's voice. And of course, he has, up until today when he took the stand, denied that he had ever been down there. He was supposedly at the house, laying on the couch, taking a nap, got up, went to his mother and father's place to check on his mom, lived 15, 20 minutes away, and then came back and found that this has happened to his wife and his son. The video itself, which has them and their voices on that would be direct evidence.
Absolutely.
Correct?
That would be direct evidence. Not necessarily that it was them, though.
Right.
So it would be direct evidence that people were there talking.
Right.
The circumstantial, I believe that it probably crosses into some sort of circumstantial evidence when other people testify the voices off camera are theirs. I think that becomes a gray area. It could be considered either one because there are the voices.
And there are the
that
voices. And if we are to assume, and it's correct, that this time frame when it was posted, 8:45.
I think he admits to it today.
He did admit to it today.
Right.
And there has been testimony that the murders would have occurred sometime between 9:05 p.m. and 10 p.m. So evidence possibly direct evidence that he was there, or at least his voice was heard there at 8:45. So that would then be circumstantial evidence that if he was there at 8:45, a jury could, if they chose to, infer
that he
that
was there when it killed him
at 9:05. So very interesting. And again, we could talk about any of these things.
There's one more.
Yes, go ahead.
Another gray area,
Sure.
kind of that circumstantial evidence is the state's position that there's only a 3-minute or 5-minute or something window of time when they could have died,
Right.
based on when that video was filmed and when their phones quit responding to text messages, right? Quit responding to text messages, and I know that that's a real issue of fact for a jury, because I know that having called you a time or two late at night, that you don't always answer your phone when somebody calls it, and
always for you.
and I don't either. But so it's an interesting. That's the fact that their phones quit answering is circumstantial evidence that they were dead. It's not direct evidence that they were dead.
We don't know why. We just know that the phones were off or they were not responding. But again, it's certainly something that a juror could infer. Hey, the reason that they're not answering this phone is they're dead. And he was just there 15 minutes before.
Right.
So, again, this is the whole process, direct, circumstantial evidence, all that is stuff that's interesting. You and I could talk about, and often do, all day long. But I want to, in the time we have today, kind of hit on a couple of other subjects that have become really, they've come to the forefront in this trial. And again, it's stuff that you and I see and hear every day, you more so than me in your area of practice. But when we talk about evidence of prior bad acts,
Right.
Okay, and before we get into, and we won't get bogged down so much in the specific rules, but in general, what is the rule, before we get into exceptions, what is the rule when it comes to introducing evidence? First of all, what is prior bad acts in the law? And then what's the general rule as to the admissibility of those?
So to get there,
Okay.
I know I'm long-winded, but to get there, we have two basic beginning rules in the rules of evidence for trial. Rule 401, which is a rule of relevance, right?
Correct.
Any evidence that's admitted at a trial has to tend to prove or disprove a material fact in the case. That means it means to show something did or didn't happen that matters.
Of the case, the
case
charge
in front
is
of
being tried at that point in time.
Right.
Okay.
So anything that comes in has to be relevant. It has to have a tendency to prove or disprove any part of the case at hand.
Correct.
So then all of that evidence, even once it's found relevant, then has to go through what's called our Rule 403 balancing test. And we've heard in this case particularly Rule 403 thrown around a lot.
403, 404.
Particularly in the character evidence.
Absolutely.
So Rule 403 says that in every piece of evidence, after it's deemed relevant, after it's deemed to prove or disprove an element of the case, once it's deemed relevant at that point in time, then a judge has to say, is the probative value, the value that it has to the guilt or innocence of the defendant, outweighed by its prejudicial value. So in this case, that balance could very well be, and has been in this case, does the evidence that he stole money from all these people weigh in the fact whether he's guilty of killing somebody?
Right.
And so in this case, the judge has let in a lot of that evidence of the larceny.
Let me stop you there before we get into the actual balancing. All right, so we said this when we got started. This is a double murder trial.
Absolutely.
We all know, and now the jury all knows, that Alex Murdaugh did allegedly, and I think to a certain extent he's admitted some of it. I mean, he signed confessions of judgment admitting that he stole $4 million from this client or whatever. Let's just say we know that he was a low-down, rotten scoundrel that had a lot of people fooled for a long time, law partners of 30 years, family, close friends. He's a thief. He's a scumbag. He's everything that we as lawyers don't like to see happen, because then it makes us all look like we're that way, and that's a subject for another day, because that's a very small percentage of lawyers, I believe. But okay, he's a dirty, rotten scoundrel. he is a thief. He took money from clients. He took money from clients who were disabled. He took money from the estate's clients who passed away. I mean, these were people that entrusted, and these were in cases like cases I do, civil cases. And he was also taking millions of dollars from his law firm.
Right.
You and I are partners. We have other partners. Same process works for every law firm. It's not my money. It's not your money. It goes into the firm. And at the end of the year, if we've been successful enough and blessed enough that we got a profit, then it is distributed. If not, then we pony up and do what we got to do to make the firm work. And so he's taking money out of his partner's pockets. He's taking money from clients. And let's just accept for the purposes of today's discussion that all that's true.
Still don't mean he killed nobody.
It still doesn't prove, or does it, that he killed somebody. So it's evident, this evidence, and clearly, and you and I believe that there's a truckload of direct evidence that can establish he
stole money.
100 financial crimes. And the judge says, or the judge is trying to determine, does that have any probative value in a double murder case? The state in this case, and get you to put back on your prosecutor's hat, the state says, yes, Your Honor, this has probative value. Now, before we get to the prejudicial effect, this has probative value. And in this case, the probative value that the state is asserting is motive.
So
tell us about that, and how is the state bridging that gap and making that argument?
So that falls under character evidence,
correct?
Right, like we're getting into. So the rule says that character evidence cannot be used against someone strictly to prove compliance with their character. Like, I can't say a state can't come to you and say you're a dirtbag because you stole from this guy, so that means you're a dirtbag and stole from this other guy because you're a thief, right? So there are exceptions to that rule. And just like every rule of evidence, there's a pile of exceptions. And one of the exceptions is to show a motive, right? So the state's position is, this is probative because it's going to show that he was strapped for money, he was being sued for this boat accident, his financials were going to come out, his wife maybe was going to leave him, his financials were going to come out, somebody was going to find out that he stole $10 million, let's say.
Right.
And as a result of that, the pressure was on him and he needed to go kill his wife again. So that probative value has to be weighed against the prejudicial effect of letting all of this stuff in to show he's such a dirtbag you should convict him anyway. Is the state really trying to say these things, not for the things they put on the record, but to show that he's the kind of dirtbag that will kill somebody, so let's go ahead and jam him up because he's a bad guy.
Right.
And that's a tough decision for a judge to make.
Exactly.
I personally think that some of these rulings that have been made on the opening of that's called, we're not to opening the door yet, but sometimes another exception to character evidence is that if the other side makes it an issue, makes it relevant. That's called opening the door. Right. So let's say that Alec Murdaugh's lawyers start talking about all the money that he stole. Then that opens the door to allow the prosecutors to bring in some of that evidence.
You put it out there, it's fair game.
Right.
Okay.
That, though, is still subject to that probative value versus prejudicial value.
Right.
Test under Rule 403. And that's where it gets a little convoluted, because that's a difficult decision for a judge to make. How far do I let you go down this road? Until we realize that it's just piling on. It's cumulative. We've gotten to a point. Cumulative evidence in South Carolina. I don't believe the federal rules have a ruling against cumulative evidence. You can just stack up certain types of evidence over and over. But South Carolina, we have a prohibition against cumulative evidence. Once you only say something so many times, but pardon me. But in this particular matter, that balancing test goes directly to character evidence. They all fall under the Article 4 of our Rules of Evidence. Article 4 is literally titled relevancy. and its limits. So that's that decision. What's relevant under Rule 401, like we talked about, and then is it probative, more than prejudicial under 404, and then any of the other rules that come up have to be filtered through all the rules before it,
right,
to get to them. And character evidence is not admissible to prove conduct, and there are exceptions. You can be impeached on other crimes. So if you've been convicted of a felony, I don't believe Mr. Murdaugh's been convicted of anything whatsoever to this point.
Yeah, no.
Prior bad acts, right? You've dealt with that in cases before.
Absolutely.
I've dealt with it. Prior bad acts, and you get into a question of what is a prior bad act. And the judge's discretion and latitude are very wide in that. And there is a chance, and I don't know this, but there's a chance that one of the reasons that the defense is getting into these issues that are so close to the line on probative value, prejudicial effect, or so close to opening the door that they're building in appellate issues. And as you're aware, in trial, and under South Carolina law, you have to make what are called spontaneous objections. You cannot appeal an issue to an appellate court after your case is over. Let's say Mr. Murdaugh was to get convicted. You can't appeal his conviction on any issue that you didn't object to.
Right. That preserves your right to that appeal.
And if you look at this case, I think there's been a whole pile of them.
Yes.
And when these objections come up, they must be ruled on by a judge. And anything you didn't object to is not an issue for appeal. So now the appellate courts, should he be convicted and appeal, get to look at all these evidentiary rulings by the judge and decide whether the judge did them right or wrong. And then the appellate court, if they found out that the judge were to have done something wrong, would have to rule on whether that actually made a difference or not. Right.
And let's say that, and we don't know, but let's say he is convicted, and almost certainly an appeal will be filed, and almost certainly one of the grounds for that appeal is that the judge's decision to allow this evidence of the prior bad acts, the financial misdeeds, stealing from clients, stealing from his law firm, that even though that may have had some probative value to establish motive, that the prejudicial effect was far too much. It just far outweighed it. And especially in a case where it seems like the direct evidence is there's some, but it's very little. And so if your entire case, if the majority of your case is based on circumstantial evidence, I would think that that attorney arguing that appeal on behalf of Alec Murdaugh can say, the jury had to be unfairly prejudicially swayed by all of this evidence because there simply was not very much when it came to the actual murders. Therefore, the prejudicial effect was far more than the probative value. Yep. He deserves a new trial.
And he deserves a new trial, or he deserves to have his sentence vacated.
Correct.
Or something to that effect. Either of those things could happen. Of course, we've seen it happen before in cases that we've handled. The real crux of an appeal would be whether or not the errors that the judge made, if they were decided the judge made errors, whether they were harmless or harmful, right? If they were harmless errors, then the conviction stands, everything goes forward. But if the appellate court decides that it was enough, that there was so much on the opposite side and they let it in anyway, then they could set aside the conviction, give them a new trial, or throw the case out.
And in this situation, I mean, if you just tuned into the case, let's say 2 weeks into it, and you watched it for 3 or 4 days, there was 3 or 4 days in a row where the only witnesses and the only testimony and the only evidence you heard was about the various financial crimes. And you almost were like, okay, what is he being tried for today? And so you talked about piling on.
Absolutely.
I think certainly, Judge Newman has been doing this for a long time.
Yeah, I think he's almost to retirement age. He's been doing it a whole long time.
And he's an outstanding judge. And
far be it for any of us to say anything bad about a judge, because that's not a job that I'm interested in. Yeah.
He's forgotten more about the law than I would ever know. And so can't say that he's right or is wrong. But, it would seem certainly that some evidence of this could be allowed in to establish motive. But a whole lot has been brought in.
Everybody needs to remember that we're your lawyers at the beach. And we're always here for you. Anything we can ever do for you, give us a call. We got 3 locations around the Grand Strand.